Welcome to Canadian Justice. I'm Christine Van Gyn. Today we're discussing labor law and strikes. How does the right to strike work in Canada? In this conversation, we're going to be considering two recent high-profile strikes or strike threats. The strike by the Public Service Alliance of Canada, which represents 155,000 federal government workers, and the just resolved threat of a WestJet pilot strike. The right to strike has existed at common law in Canada for decades, and a 2015 Supreme Court decision crystallized and clarified that right as a constitutional one, especially for essential workers. There are a number of laws that govern the right to strike, but today, in this episode, we're going to be focusing on federally regulated workplaces and some common questions about the right to strike in Canada. We're joined by Danica McLellan, a labor and employment lawyer, and Michael Wernick of the University of Ottawa. Thank you both so much for joining me today. Danica, as I said, the right to strike in Canada has constitutional protection, and that, there have been protections at common law for a very long time, but there's a very important case from 2015 that clarified that right as a constitutional one. What can you tell me about that case?
Thanks, Christine. So that decision is known as the SFL decision, or the Saskatchewan Federation of Labor case. In that case, a number of unions in Saskatchewan challenged the constitutionality of provincial legislation, which applied to public sector employees in Saskatchewan. And that legislation said that while most public sector employees in Saskatchewan had the right to strike, essential service workers did not. And not only did they not have the right to strike, they didn't have access to any other dispute resolution mechanism. And so that's really what the Supreme Court said was unconstitutional, and said that the right to strike is a constitutionally protected right, recognizing, of course, that there still are essential service workers who, if they were to strike, would challenge governments in maintaining crucial services, which would threaten lives. And so what the Supreme Court said was that you have to either have the right to strike, or you have to have the right to another dispute resolution mechanism, such as binding arbitration.
So, Michael, as I said in the opening, the right to strike has existed for decades, including before this 2015 decision. So what types of protections existed before that Saskatchewan Federation of Labor case?
You could start the story a long time ago. It's evolved through common law and through statutes over many, many years. I think of it, I'm not a lawyer, but I think of it as sort of a layer cake of, the freedom of association. And then you build on that the right to collective bargaining about wages and conditions of work. And then some of those people that have a right to collective bargaining have a right to strike and others don't. And the right to strike has never been unconstrained and open-ended. It's always been subject to some sorts of rules and constraints, and people that work in health and safety kinds of jobs like police and correctional guards and so on have never had the right to strike. But the practice has evolved, over the years, in Canada and in other countries.
So, Danica, one thing that people always talk about and governments often talk about when there's a strike either threatened or taking place is back to work legislation. When can governments use that type of legislation, and what goes into the decision-making process of using it?
So governments will consider back-to-work legislation, which, as a function, it ends a strike. And either it ends a strike and imposes new terms and conditions of employment, so it essentially imposes a new collective agreement, or it ends the strike and it orders the issues remaining in dispute to arbitration. And ordering an arbitration is definitely the more common practice now in back-to-work legislation. Governments, generally speaking, won't use it on day one of a strike. Usually, they'll only resort to it when there's been a really serious negative impact on the economy. For example, port strikes, rail strikes, Canada Post strikes, things like that.
Michael, we've only got about 30 seconds left. Anything you want to add to back to work legislation and maybe how it has been used in the past?
Well, I think the difference between a private sector employer and governments is private sector employments can't force an end to a strike, but governments can. And so courts have actually given governments a very high test to bargain in good faith before they use this tool.
Right. Now, you raised something interesting there, Michael, which is the difference between negotiating with a private sector versus public sector union. The public sector strike we just saw ended a few weeks ago was obviously public sector. WestJet, while federally regulated, is a private sector company. When we come back, I want to talk about the difference between the two types of negotiations.